Hello, I'm Robert, and helping you if you're scared of many things by fact checking. And this is people who are scared that the they look at the Supreme Court's decision to overturn Roe versus Wade, this which establishes the right to abortion, and then they think that the Supreme Court has gone rogue basically, and they think, oh, well, this is a group of justices that are no longer being proper justices, and they just have the idea, they get the impression that the Supreme Court wants to establish a Christian theocracy, autocratic theocracy, fundamentalist theocracy or something. And this is not true at all. So these are just ordinary justices. I've looked very carefully at it, and they make the legal decision. So I've got an example, and this will seem rather a strange example to you, but you may not know that just like you have these different ideas in law, you have these different ideas in maths. So this is in an area of mathematics called set theory, or fundamental mathematics, and there's an axiom called the axiom of choice. And you have two groups of mathematicians. Some mathematicians will do mathematics with this axiom of choice, and some mathematicians will do mathematics without, and then some mathematicians will look at the two types of mathematics and work out how they interrelate to each other. And the axiom of choice is a very innocent sounding axiom. So it's when you want to talk about infinite things. So mathematicians are always talking about infinity. If you've ever learned differentiation or integration, then they're always talking about infinities there. So you need to know how to talk about infinity. So the question, this is this is the way that mathematicians explain it to everyone else. And they take the example of an infinite number of pairs of boots. Then, if you want to select one boot from each pair, then it's very easy to do that, because there's a distinguishing mark, the left boot and the right boot. And you say, I'll choose all the left boots. Or you could choose alternate left and right boots, or whatever. There will be many ways you could choose one each from an infinitely many sequence of pairs of boots. But now, if you have infinitely many pairs of socks, then there's no distinguishing mark. The left sock looks exactly like the right sock. You never stop and check which sock you're putting on which foot, because they are identical. So this needs an extra axiom, because there's no distinguishing mark. There's no way to tell which is which. So that is the axiom of choice. And so you might think, well, sure, it's obvious. You could just pick one at a time. But remember, there's infinitely many of them. If there are only 10 of them, it'd be very easy. You just pick one of each. But how do you pick one each of infinitely many when you don't have a systematic method of choosing one from each of infinitely many pairs of socks? So you have to add an extra axiom which says, yes, you can choose one each from infinitely many pairs of socks. Now, that seems like an innocent seeming axiom, and why don't just all mathematicians just assume that? Well, the problem with that is that if you can do a lot of very complicated mathematics, and using this very innocent looking axiom, you can take a sphere, just an ordinary sphere, but in mathematical spheres where it's infinitely divisible, and you divide it up into these very complicated pieces made of very intricate pieces made of lots and lots of dots. It's just lots of points stuck together in a complicated way, but they're rigid pieces. So you've got basically a kind of cluster, almost like a galaxy of stars or something, cluster of dots, but every point in the sphere is in one of these 5 pieces. And you can pull them apart, and they kind of pass through each other. They're very unusual pieces. You slide them apart, and then you push them together again in a different way, and you get 2 spheres. And these 2 spheres have the same volume as the original 1 sphere. if you have the axiom of choice, you can define 5 pieces, a way of splitting a sphere into 5 pieces, which can then be put together in a different way to make 2 spheres of the same size, with no gaps in either sphere, and with every point in the sphere belongs to one of the pieces, and no point belongs to more than one piece. And yet now you've got 2 spheres, and originally you had 1 sphere with the same property. So this is why some mathematicians then look at that and say, well, that shows that we just shouldn't use the axiom of choice. But other mathematicians say you can use it, you just got to be careful, because you get strange conclusions in some situations. So I use that because that is something that is, now suppose that this was a great legislative consequence for some reason, whether you can choose one from each of infinitely many pairs of socks. Then you would have the same situations with mathematicians, that for legal reasons, probably half the justices in the United States are willing to work with a legal system in which you can choose one each from infinitely many pairs of socks, where the other half say, no, we can't be doing with that. There'll be a third group of legislators who say, well, you can use both at once in different situations, you can compare and contrast them. So now you have your Republican and your Democrat presidents, and suppose that being able to choose one each of infinitely many pairs of socks is of great legal importance for Republicans, whereas not being able to do that is of great legal importance for Democrats. Then the Republican president will choose justices who have not because of the axiom, but because of its consequences. So maybe you get right to abortion can be derived from the ability to choose from one each from infinitely many socks. Let's just suppose that for an example. Suppose that through some very complicated legal argument involving infinities, you can derive the right to abortion so long as you can prove that you can choose one from each of infinitely many pairs of socks. And just for instance, obviously that would be a real situation. Then the justices are just using legal arguments. It's nothing to do with their personal views on abortion. But the Republican president will obviously choose the justices that are willing to argue using the axiom of choice, whereas the Democrat ones will choose the justices that are not willing to use that argument. Well, it's exactly the same situation here, because they don't do it based on conservative values, they don't do it based on liberal values. The conservative justices are not really conservative. It's the conservative and liberal is a view that others have of them. If you ask them what their interpretive philosophy is, they'll say, I'm an originalist, and they will go into great details of a particular style of originalism, as to, for instance, whether they think that the notes that the framers of the bills make and the evidence of how they thought as they were framing the bill, whether that's important to how you interpret the text of the bill. Then some originalists think that's very important, some think it's less important. And they'll come to different legal decisions depending on what kind of originalists they are. And so that's very much like the axiom of choice that I was talking about. So that's how the justices themselves think about this. And so the ones that have chosen to overturn Roe versus Wade, they did a long, complicated argument that basically is like deriving the conclusion that you've got to overturn Roe versus Wade from a premise that you can choose one each from infinitely many pairs of socks, which they choose on the basis of the legal arguments. I mean, it's other things, but I'm just not going into the details. I do in my longer video, I go into legal details. But here I'm doing a shorter video to try and get over the flavour of it. So then it so happens that from the particular legal principles that lead them to overturn Roe versus Wade, those legal principles do not overturn any of these other things. They don't overturn the right of conception or interracial marriage, and Justice Thomas agrees on that. So there's a whole group of, and so instead of choosing one each from infinitely many pairs of socks, it is about whether a fetus has an entrenched right of liberty. And it is not, they do not have the belief, it's not based, so whether it's an important, it's one step back from that, it's whether it's an important question in questions of reliance, that about whether or not a fetus has an entrenched right of liberty. That is what the Conservative justices think. They think that it's an important question that needs to be considered when considering reliance, is whether or not the fetus has an entrenched right of liberty. Everyone agrees that the woman has an entrenched right of liberty, but does the fetus have? And the justices say that this is not something that justices have the authority or the expertise to decide. So they say that they say this has to go back to the American people and the voters. Voters and legislators can decide things like that. Justices can't, because justices just interpret the law. And so that is why it's a very different thing from the gay marriage, where there's no other conflicting entrenched right, not potentially conflicting. So the Conservative justices do not say that the fetus has an entrenched right to liberty. They don't say that. So they don't say that abortion should be banned. They just say that 26 of the US states have said that Roe versus Wade should be overturned. They do that on the basis of the idea of an entrenched right of the fetus to liberty, and they say this is not a question that justices can decide, and the American people have to decide that. And the entrenched right of liberty of a fetus, whether or not it exists, is irrelevant to whether or not women rely on abortion as for the way that they understand them for intimate relations and the way they see themselves in life, because that is a liberty as well, and in the way the two entrenched rights of liberty interact, and whether it is just up to the woman to decide for herself, or whether it's something that society has to decide through a legal system. And so the liberal justices, and this is based on a different legal interpretive philosophy, it's not based on liberal values. And so they don't agree that you can choose one each from an infinite pair of socks in this analogy, and based on not assuming that. So choosing one each from an infinite pair of socks is like the entrenched right of the fetus, and then the other ones, I'd like whether there is a question about the entrenched right of the fetus. And the liberal justice says there isn't a question that the Supreme Court should even think about, and this is something for individual pregnant people, sorry, not women, I should say, I forgot to say that, pregnant people, not women, because you get pregnant trans people. I forgot to say that in the longer video. So the liberal justices say that this is up to the individual pregnant person, and it is, or potentially pregnant person, and this is not something that justices, and for justices to overturn Roe versus Wade is to interfere in this and prevent this liberty of choice. So they have these. So these are the two legal arguments in a nutshell on both sides. So as you can see, this has absolutely nothing to do with gay marriage, and absolutely nothing to do with the right for contraception, because they, unless possibly the morning after pill, then but that's quite an extreme view about whether there's an entrenched right to a fertilized egg on the first day, and I don't think many people would say that, and nothing to do with interracial marriage. So so that's the that's the Roe versus Wade, and then this way it interacts on that. So Justice Thomas, he is in a 1/8 minority, and he is not questioning this. He agrees that this reasoning, which I just explained, about the infinite pair of socks analogy, but about the entrenched, whether the entrenched right of fetus has anything to do with this question, whether the question that there is an entrenched right of fetus is anything to do with what the justices decide, then he agrees that reasoning does not affect any of these other decisions. So he instead wants to challenge substantive due process. And so substantive due process is quite a tricky thing to explain and understand, and but it's based on just two words in the Supreme Court, in the amendments to the Constitution, which are repeated twice in two different amendments. And it's just it's just four words in the Constitution. So now there's a difference between how justices think in their judicial decisions and kind of informal discussion. In informal discussion, I think most people agree that it's a kind of pretty slender basis, that which is substantive due process. It's just based on those four words, and it's how you understand due process. So anyway, yeah, I haven't explained what just substantive due process is. So substantive due process is the idea that you have rights. So I talked about the right to the fetus and the right for the woman. Those rights are not in the US Constitution or any of the amendments. There's no mention of anything like that. So, but substantive due process says that there are lots of inferred rights, and it bases those on just these four words. Two words repeated twice. And they say that due process there means substantive due process, which means that you have to it's about having to go through the due process of law, and they say that due process includes taking account of entrenched two things. They say there's entrenched right to liberty. I talk about the entrenched right to liberty of the fetus. The fetus has right to liberty. So does the mother. So I mean that the people who reason pro-life say that the fetus has an entrenched right, and so that's the idea of an entrenched right, which is a right which. So if you overthrew a substantive due process, indeed, then the fetus doesn't have an entrenched right, nor does the woman. So I'm not sure what that would do to Roe versus Wade, but so there's lots of things would get overthrown. Decisions over the years, quite a few of them would get overthrown if you get rid of substantive due process. And this would mean that a whole lot of things would have to be legislated by Congress, because the Constitution doesn't say anything about them, and if you can't use substantive due process, which is based on just four words, then you just can't derive these rights from the Constitution or any of the amendments. So substantive due process, based on those four words, it has two ways of deriving rights. One is that it derives them through the entrenched right of liberty. So if something impacts on your liberty, then that is an entrenched right to liberty. That then is something you use substantive due process to say that that's not permitted. And then the other thing is based on history. And so if the American people have in their history, then this particular thing, like past legal decision, past ways of understanding law going way back before the Constitution, and the way people understand things, not written down, unwritten understandings that they have, and things like that. And so they then in legal cases, they examine all this sort of stuff to try and work out if there's a historical substantive due process. And then they also have other ways of reasoning. And so with Roe, they decide there's no historical substantive due process. But there is that Casey says that there's nothing to do with privacy. In that they agree with Casey. And then the last thing is whether there's an entrenched right of liberty, and then on that they decided that they can't decide, basically. They say that the American people and the voters have to decide that. They say it oversteps the bounds of the judiciary, while the three liberal justices they don't see what any of this has got anything to do with Roe versus Wade. They just don't think the question of whether a fetus is an entrenched right is something that should be brought up in this conversation at all. For justice shouldn't even look at that. That is something for a pregnant person to consider, and not something that the justices even need to think about. So that's how the Liberals think about it. Whereas the Conservatives say that justices do need to think about this, but they can't make a decision because they don't have the authority or expertise to do it. And that is basically the division that we've got in the court. So based on this, hopefully you can now see that there's no way that they are going to. So he's in a minority of one called Nate because, and so the Roe versus Wade decision was based on substantive due process all the way through. They actually used it. They examined the history, they examined the entrenched right of liberty, they looked at reliance as well based on those. And so, and they didn't question it at all. And none of the justices except Justice Thomas says anything to suggest challenges for substantive due process. So if this ever came to a case to the Supreme Court, it's likely to be an 8-1 decision against him. And then another thing that leads to a kind of similar, if you look particularly at LGBT rights, then the Supreme Court, if I go all the way down, first of all, 6 of the Supreme Court justices are Catholic, but one of those 6 is Sotomayor, who's a Catholic and voted to keep Roe. So it isn't a Catholic decision. It's based on legal interpretive philosophy. It's not based on their religion. And in the United States, 59% of Catholics, actually 56% of Catholics actually support choice. And I think it should be a no. Even though that would presumably not be what they personally would do. So, based on that, we expect 3 of those justices would probably, and they may well, in their personal life, actually would choose pro-choice. And if it came to, and maybe in the midterms, half of those justices will vote for Biden, will vote for the Democrats. They may well be pro-choice and vote for Democrats, but they are very careful to erect a very strong barrier between their personal views and their judicial decisions. And they won't tell anyone how they vote, obviously. And it's well possible that some of them vote Democrat, because that's the way justices work. And it would be an utter scandal if they were to use their, if they were to vote, make a decision based on how they vote. If you were to go to if your case was taken to court and the court and justice was to say, well, because I'm a Democrat, I'm going to sentence you this way, and then if you go to a justice who happens to be a Republican, he sentences you a different way, that would be an absolute scandal, and that's not how justices work. So, and then lots of people worry. They think that these justices lie. And if you go and look at their confirmation hearing, then none of them say how they're going to decide on Roe versus Wade. And that, if a Supreme Court justice in his or her confirmation hearing was to say, I'm going to decide this way on Roe, then they should be disqualified and not approved as a Supreme Court justice if they were to say that. Because this would be saying that, because the thing is that, like this case, it was a particular case with a legal argument both sides, and the plaintiffs coming to the Supreme Court. If the Supreme Court's already decided before they even go to the case, what's the point in the Supreme Court? They're not going to read your legal argument because they've already decided. That would be extremely unprofessional. So, if you look very carefully, they say that they would consider reliance very carefully, but the justices do not say that they would decide against or overturning Roe. they can't. And as I say, they would be disqualified if they did say that, or they should be. So that's something to bear in mind. So they are not lying. They're not in some kind of political agenda. They're not trying to change the... and indeed, this particular decision to overturn Roe may well lead to Biden getting 2 more seats and then carve out of the abortion and then codifying Roe in law. Now, suppose that the justices knew all that. They couldn't. It would be, again, extremely unprofessional and wrong for them to say, well, we don't want Roe to be codified, so therefore we'll decide a particular way. They can't do that. They're not like legislators. So, so some of them may well be pro-choice, and they may well vote in a Democrat who will then go on and codify Roe. And there's nothing inconsistent about that. To make a judicial decision to overturn Roe, and then go and vote for someone who is going to codify Roe, and the same person could do both. And that's entirely consistent and normal. That's how justices work. And then I think I'll just talk a little bit about something that a lot of people don't understand about legislators too. So if you look at judicial decision making is very different from the way legislators work. So the way legislators work, again, they don't just use their personal opinions. They may seem to, but that's not really how they proceed. So Biden, when he talks and he says this or that or the other thing, he is not expressing his personal opinions. So Biden, when he was Obama's vice president, would say one thing, and now when he's president, he'll say another thing. The reason is that as vice president, he was on Obama's manifesto, whereas as president, he is using Biden's manifesto. The manifesto is not just his personal views. The manifesto is based on him talking to his advisors and lots of discussion and bringing up something which, in his view, expresses the will of the American people, or something that the American people could vote for as their will. And that is the theory of democracy. The aim of the president in a presidential democracy, in indirect democracy, you have direct democracy where people choose directly for all the decisions or some of the decisions. You have an indirect democracy where the people choose a legislator who then makes decisions, and they typically have a manifesto. And so in the manifesto, Biden sets out what he plans to do, just like Trump said in his manifesto he's going to build a wall, and that's why he then put a lot of work into building the wall all the way through, because that's what he said he'd do between Mexico and the United States. So in Biden's manifesto he says various things, and so that then is what he will do as president, and that's what he's got a mandate to do. And he hasn't got a mandate to do other things which he might personally want to do. So that is the theory of democracy. And it's the same with representatives. So a representative, when they are elected, they will campaign saying that they're going to do certain things when they become representative. So they will vote in a particular way in Congress. They will bring bills to Congress and things like that, based on what they told their constituency and on feedback constituency, talking to them and so on. But they have the mandate to do that based on what their constituents tell them. So they don't really just say things based on their personal views either, at least if they're doing it professionally, they're doing their job properly. So they have their personal views as well, and the people who elect them because of their personal views. They like them as a person, they agree with their personal views. But on big things, then the manifesto is the real thing that grounds what they have, and then the election pledges of the representatives and the individuals in the legislature. So that is how the legislators work. And then the way that the judiciary work, the judiciary don't do that. Nobody voted them in. They don't represent anyone. They're not trying to present the views of the American people. They're not representing anyone. They're not representing America. They are looking at the Constitution and the laws passed by the legislature. So the views of the people become law. The law then is interpreted by the justices using the Constitution. And then there's a process of amending the Constitution if the Constitution starts causing problems. But the justices can't amend the Constitution. So justices can't do anything that's against the Constitution, but there are lots of ways of interpreting the Constitution, like this whole substantive due process thing. And so that's how the justices think. And the justices, they do look at how the American people behave. They look at whether, for instance, questions of reliance depend on looking at. So, for instance, they see that there's been gay marriage for a long time, and there have been many gay marriages. So, for instance, if Overfell had passed and there'd never been any gay marriages since then that would show there's not be any reliance on it. So, in that sense, they do look at what the American people do. And there's been lots of gay marriage, and these gay marriages have been stable, and people have built their lives based about the right to have a gay marriage, and lots of legal things based on that too. And so that's reliance. So in that sense, they do look at what the American people do, but they are not representing, and they're not presenting the views of the American people. That's not their job. They just look at them for questions like things of reliance and historicity, and liberals will look at how the way the meaning of the text has changed as time has gone on. So that's how people understand things now compared to how they used to understand them. So that's what's going on there. Oh, I see that I should maximize this. Oh, it is maximized. F11. Yeah. That's funny. I shouldn't be seeing this bit at the top here. Never mind. I can change that. Anyway, so that's that. Then just one more thing that I have to I wanted to talk about. So I've got a longer video which I'll go into some of these in more detail. Talk about how interracial marriage isn't prohibited anywhere, as far as I know. There were a few places where it was prohibited by custom, but not by law. And the United States was one of the few places that actually did have laws against interracial marriage by 1979, but hardly anyone else put it in law. It was just custom. And in China, there were hardly any interracial marriages. There weren't any in 1979, according to the source I saw. But it wasn't, and it's the same in some Muslim countries. Muslim women won't have a non-Muslim man as a husband. But this isn't. This is a custom. It's not a law. It's only in some countries, but it's in those countries that it just doesn't happen. But it's not a law. So the interracial marriage isn't prohibited by law anywhere, as far as I know. I should say by law there. And so if there was a case, if the case of interracial marriage did come up in the Supreme Court, then Justice Thomas would have to accuse himself, because he is in an interracial marriage himself with his wife. So he's obviously very personally involved. So that would be an 8-0 decision in that case, because even if it's possible that he might, if he, based on challenging substantive due process, decide that his own marriage is illegal, based on, but he's obviously be very conflicted in such a legal decision, and he'd have to accuse himself. So, because you have these very big barriers in between, it's not impossible that that someone could have a legal view that their marriage is illegal, but even though it is legal, anyway, that is not likely to come to court, and even if it is, I think it's highly unlikely that Justice Thomas would have that view, and even if he did have that view, he'd have to recuse himself, so it'd be up to the other justices. So there's no way that's going to happen. And so then I was going to look at gay marriage. Then first of all, so in Catholic countries show, and I did say about how you've got six Catholic justices, and the Supreme Court, and one of them voted to retain Roe. And did I say that 56% of Catholics are pro-choice in terms of law, not in terms of personal decisions. Well, in the United States, but if you go and look at other Catholic countries, then only recently have they actually come out to decriminalise abortion, and yet they all have had gay marriage for quite a long time, and several of them for judicial decisions, including Brazil is quite a clear case. It's still got abortion is a crime, which with a sentence of up to several years for the woman who has an abortion in Brazil. But gay marriage was made legal in 2013 in Brazil by judicial decision again. Judicial decision for gay marriage in 2013. So they're independent of each other, even in Catholic countries where everyone is Catholic and their laws is presumably rather different from the United States. And same in Mexico, political decision of gay marriage is if you have a gay marriage in Mexico City, it must be accepted throughout the country. They extend it to other regions. And only in 2021 did they decriminalise abortion. So they are very distinct things in countries like that. And then in the United States, the general people. So this is out of date because Joe Biden has said that he'll do a carve out for abortion and for things of privacy. So if they get a majority of 2 in the midterms, then they'll have a possibility of codifying Roe. I think that's everything. At least I've got several other things I go into. Those are the main things in this. And yes, there's even with a carve out for abortion, it's extremely unlikely that the Republicans can't make abortion illegal, because they would have to add it to their manifesto, and 61% of Americans are pro-choice. So if they had a manifesto saying that we're going to make abortion illegal, they just wouldn't get in. They wouldn't get a majority. And because in a lot of the marginal seats, they lose too many votes. So anyway, this is my somewhat shorter video about all this, and I've got a longer video which goes into some other details. But hopefully, I know it's a bit of a bizarre analogy, but hopefully it helped a little bit, because it's not emotive, the whole idea of infinitely many socks. And if you think of legal decisions as being based on something which for the justices is no more emotive than the question of whether or not you can choose of one each from infinitely many socks, then that's how they think about decisions like this, about abortion, about Roe. They're doing it based on legal principles, not based on conservative or liberal values, and not based on personal views or emotions.